here. Thanks for coming to the event. We're kicking off Banned Books Week as the Comic Book Legal Defense Fund. I'm sure a lot of you are aware of who we are. We're a First Amendment rights and free speech organization protecting those rights for the comic book community. Really excited to have this conversation with the counsel from the recent obscenity case, the victory in Virginia Beach. We'll have some time, hopefully at the end. Jeff's answered some questions a little bit right now, but hopefully we'll have Steve into the conversation and he and Jeff will be able to answer some more detailed questions about the case. But because there's been such a dramatic rise, American Library Association found more challenges last year than they've ever found in the entire history of them recording challenges. PEN America released a report that over 1,600 books have been banned in the past year. And in a new report that was just released today, they found that there are interest groups, well-resourced advocacy groups that are largely responsible for many of these challenges that are happening across the country. So we thought it would be a great idea to look at this recent victory with the lawyers who represented Maia, Kobabe, and genderqueer, and sort of pick it apart so we could understand it better. Oh, excellent. And here is Steven. Steven, thank you so much for getting on the call. Sorry about any issues you had with Zoom.
I've never been kicked off an entire platform like that before. Somebody in Zoom Communications is laughing at me at this point.
So
no. Oh, Jordan, and I want to thank you. I want to thank you, Steve, personally, and just let you know, all I did was talk about some of the stuff that the CBLDF did back in 2021, because I did not want to talk about Virginia until you were on board.
Okay.
So what I'd like to start with is, if you both wouldn't mind just briefly introducing yourselves, sort of your backgrounds, and then we could get started. If you could both, and especially Stephen, because it's your home court, your home turf, sort of like describe sort of the groundwork of Virginia. What was going on with Virginia? What are some of the individual laws in Virginia that allowed this case to be initiated?
Sure. I'm the late Steve Emmert, and I'm an appellate lawyer in Virginia Beach. I've been practicing law for 40 years now, and I primarily only handle appeals. I got into this one when one of the other attorneys in the case, who know me, he's a good friend of mine, said, "You ought to be in this." And at first I was reluctant, but I'm very glad that I said yes. You wanted to know what the format was for this, or I guess the landscape for this. Gender identity became a campaign issue last year. We have off-year elections, and so we elected our governor last November, 10 months ago. And in that campaign, there was a debate between the gubernatorial candidates for the Republicans and the Democrat. The Republican candidate was Glenn Youngkin, and the Democratic candidate was Terry McAuliffe. And McAuliffe in that campaign said, and I think I've got this exactly, parents shouldn't tell schools what to teach. And Youngkin immediately seized on that as a political hot button issue and said that's one of the things that he wanted to focus on, that parents deserved a better hand in what exactly their kids got taught. I don't think they were talking about teaching algebra and not teaching geometry. So they had, I think, this kind of issue foremost in mind. So that's how it began. As it's recently developed, as I say recently, 3 days ago, this new governor set out a new set of guidelines for schools, in which he formally rescinded the policy that had been implemented just about a year and a half ago by our previous Democratic governor. And now teachers are not going to be required to use a particular form of address for students. Restroom facilities will now be gender assigned at birth, and you can only get addressed by your preferred pronouns if you file some paperwork, legal paperwork for that. So that's what's going on now in Virginia.
So this is one of the things that I mentioned before in the time that you were coming up, was the now infamous school board meeting where the parent held up a copy of Genderqueer with some pages and then posted that excerpt the next day, and it went viral. And I really thank you for that, adding that additional context with respect, because that statement in the debate was incredibly important, I think, in the long run. And it's amazing to see how much these gender issues have become central to political life here in Virginia. And it's not just, we're talking about all aspects of Virginia. It's not just, say, rural portions. It's something that's affecting the cities as well.
Well, Virginia Beach is the most populous city in the state. So it's not exactly as though they picked an out-of-the-way county to bring this suit. They brought it here in one of the major population centers of Virginia. So yeah, you're right.
Yeah, it's been an incredible development, and I think a template for a lot of what we're seeing nationwide. Just to introduce myself again, I'm Jeff Trexler. I'm the interim director of the Comic Book Legal Defense Fund. And as some of you may know, I am also an attorney myself and have been in practice for a while. And so when we heard that this case was being brought, and Steve can help give you a sense of exactly what happened and how this case could be filed, which I know is baffling to a lot of people in comics. When this case was filed, I got in touch and became attorney for Maia. And then Steve joined us, and I cannot tell you how grateful I am that Steve, who I know is always has decades of practice as the king of appeals and appellate law in Virginia, but I'm so glad that you joined us because you were so vital to this case. And then together we started down this path that brought us here and ultimately to that victory in court on August 30th. And so I look forward to hearing more just in this discussion about all of that means. So Jordan, please.
Yeah, so I am not a lawyer. I am the digital editor for the Comic Book Legal Defense Fund. So I'm hoping to kind of break things down a little bit for those of us who maybe don't have as much of a law background. So I'm curious, what exactly was the initial complaint against Genderqueer? How were they able to bring it forward? And then how many parties were involved? Because I know that you all were representing Maia, and I know there was a lot of different parties that were being represented through the case. So I wonder if you could tell us what exactly the complaint was, how it was allowed through law, and how many parties were involved.
And I'll just set up really quickly, and I'm going to throw this to Steve, just how weird this is if you work in First Amendment law or obscenity law. Normally, when we've dealt with cases in the CBLDF, every other obscenity case that we dealt with, somebody had been arrested. If we're going to court, somebody had been arrested for selling obscene material, distributing obscene material, possessing obscene material. And yet here, nobody was arrested, right, Steve?
Right. Virginia has a statutory framework that allows a party to seek an advance ruling before anybody gets arrested that a particular material is obscene. And if the court, after a given trial, finds that the matter is obscene, then that results in a declaration that under Virginia law, presumptively everybody in the state is presumed to know that the material is obscene. And anybody thereafter who is caught selling it, distributing it, maybe even possessing it, is subject to being charged with knowledge of that obscenity filing. So that was one of the issues that the parties focused on in briefing in this particular case, and asking the judge to rule that statutory framework is just unconstitutional. But you ask how it was done. There was simply a petition filed, actually parallel petitions, one for Maia's book and one for another book that was non-graphic. It was the text novel, and filed them in the circuit court. They convened a hearing before a judge. Now this is a one party only. It's what the lawyers call ex parte, means without one party. So the petitioner showed up. He was the petitioner himself was a candidate for the nomination for the Republican seat in Congress here in Virginia Beach, and he was represented by a Republican state delegate who was a lawyer. And they filed this petition, appeared before a judge, and convinced the judge after this ex parte hearing that this matter was obscene, this book and the other book as well. And so the judge issued something called a show cause order, a preliminary finding that there was probable cause to believe that the material was obscene. So at that point, that's when the party had to notify, that's when the petitioner had to notify everybody. He did that by sending copies to Maia and to the publisher, and also by publishing something. In the like the one ad section, this is the legal notices. It's in about 3-point type. So even if you're young and have good eyes, you need a pair of reading glasses to read it. This is actually the copy that arrived on my driveway that morning just before Memorial Day. And This is presumed to be knowledge or notice to everybody in Virginia, at least everybody within the readership area of this particular newspaper, that says this case is pending, and if you want to protect yourself, you got to do something. Barnes and Noble, I think, was originally the first one to intervene. Is that right, Jeff?
Yeah.
They obviously have a major interest in finding out whether they're going to be charged with distributing obscene materials. So that's what happened there. They filed that, had a preliminary hearing with just the judge, then notified everybody, and then we started descending upon the court in order to file our legal pleadings in response to it.
Yeah, this was literally, and I think it's fair to say this, Steve, this was a book on trial, right?
Yeah, I think the very first word that we put in our brief, the very first sentence was, the purpose of this litigation is to censor literature.
Mm-hmm.
And I stand by that. I mean, Jeff and I talked about that. We agreed that's the way we ought to lead, because I think that's really what it was about. The petitioner repeatedly said, we're not here to ban books. But I don't know how you could say that with a straight face, considering that the objective was to say, this is obscene. Mm-hmm. That was the whole purpose of the petition in this case. Mm-hmm. That's how it got started.
Yeah.
So I'm curious, now that the case has gotten started, there's the various parties, what was the back and forth? I know there was the initial complaint and then you all had responded. Did the other side have a chance to respond? And then did you respond in turn to that? When did you actually go in front of the judge? What was the sort of the flow and anatomy of the case?
Good question.
I'll take that. After the parties were notified, they had an opportunity to file responses. An answer is what was done, and that the judge had given a deadline for an answer, and we all answered. I say we all. We answered on behalf of Maia. Maia's publisher answered separately. The other book publisher and author answered together, I believe. Barnes and Noble filed an answer. An amicus curiae filed a response saying, hey, we won on this too, because we think it's important that our voice be heard. After those were all in, the judge issued an order that said the parties are allowed to file briefs, legal arguments in writing by such a date. We got the chance to file first because we filed a motion to dismiss their case, and that's what this was about. The petitioner got to file his response, and then we were allowed to file a reply. That was all done in mostly the month of July, late June, early July, and the court, and I guess into early August. And the parties convened before a judge in person on August the 30th. So that's about 3 weeks ago. And we had a hearing before the judge just on the legal issues raised in our motions to dismiss the case, not on the merits of whether it was obscene or not, but just to say this case can't fly, and ask the court to strike it down. That about right, Jeff?
Yeah, that is it. And just to give you a sense of how courts live in a world that's different for many of us in the comics world, the first brief that we had to file was due the Tuesday after Comic-Con, which was made life a lot of fun. So it was a pretty intense period of time, but it was really interesting because first of all, Steve mentioned that we had these briefs on behalf of different people, and one of the things that was interesting for me to see as somebody who's working in the First Amendment space is how this case brought in everyone. I mean, this was, you could imagine every First Amendment lawyer was interested in this case. And if they weren't doing a filing in this case, they were trying to do a filing in this case. And we had these amicus briefs. There were bookstores were coming in and filing, and different nonprofits were coming into filing. And we were at the center of it as representing Maia, along with the attorneys who were also representing the other parties. And so it was fascinating to have a front row seat to this case that really was in many ways shaping the discussion of First Amendment law over the past summer. And I think that people are going to be looking at this one for years to come.
So where do things stand now with the case? You said people will be looking at this from years to come. What are the lessons sort of that we can learn from this case? And is there any legs to this case in Virginia Beach beyond what has already happened?
Steve, you think maybe we can break down the major points that in the court's ruling? Sort of talk about, just talk about exactly what the decision was, because there's been a lot of back and forth in a number of articles, and I think we've both seen some misrepresentations of what the court's ruling was and what the effect was. And I think it'd be great to just sort of break it down, and, you know, for our attendees and anybody who's watching on video, say this is actually what happened. So we're going back and forth. We're talking about a bunch of issues. We were talking about the question of obsceneness to minors. We were talking about some First Amendment issues. Steve mentioned the due process issue. There's also an issue of prior restraint, the government stopping the distribution of a book. We were talking about a number of different things with respect to the First Amendment. We were talking about visual representation and that sort of thing. So I'd be interested in just sort of having a brief discussion on what was in that ruling. What did they decide? And equally important, what didn't they decide? What didn't the judge decide? By they, I meant the judge, sorry. What did the judge decide, and what didn't the judge decide?
First thing I'll mention is that I was slightly surprised on August the 30th when the judge went ahead and insisted on entering, she listed rulings right then and there, and insisted on entering an order that day. I would have expected her to say, I'll take these findings under advisement, I'll think about it, I'll give you a letter opinion, and then you can circulate an order. This judge was having none of that. She was ready to rule that day. And so she indeed did list a series of specific legal findings from the bench that we all heard that day for the first time. And we embodied it into an order. And I've got the order here. The first couple of findings are fairly Virginia specific. It says that the Code of Virginia doesn't allow a court to find something as obscene as to minors. The petitioner continued to insist that he wasn't asking for a finding the book was obscene generally to the general public, just as to children. So the court first ruled that the statute doesn't allow that. Second, it says that the petition that he filed doesn't allege facts sufficient to establish a finding of obscenity. Now we get into the meatier ones, and this is the one that I think that will probably be the biggest. I'll call it a lesson, but the biggest news item of this. And I'm just going to read this one sentence: the constitutions of the United States and the Commonwealth operate as a constraint on the pleading of a claim of obscenity as to adults and as to material that's inappropriate for distribution to minors, and the petition fails to meet the requirements of the governing constitutional rules. So essentially the court was saying, this doesn't set forth a claim that this book is actually obscene. The next finding was that was a real whopper. The court found that our statutory scheme, the one that I told you where you can get an advance ruling whether something is obscene or not, is unconstitutional. And that it's unconstitutional on its face because it imposes a presumption of knowledge. That's what Jeff mentioned about the due process. You have a right to know before you do something whether it's illegal or not. And what this statute says is, once a judge down in one corner of the state issues a ruling, everybody in Virginia is presumed to know that it's obscene, and so therefore can be prosecuted in any other corner of the Commonwealth. The judge found that that was plainly not constitutional. Also found that it was it violates due process by authorizing judgment without notice. The one thing that Jeff mentioned is one thing that we were hoping to get that wasn't done, that the judge did not do, was enter a specific finding, which the Virginia statute allows, that the book is not obscene. That would have been useful as precedent here and elsewhere in Virginia. We like to get that because we like to finally have this matter resolved once and for all, at least in Virginia. The judge didn't give us that, but instead she threw out the entire statutory framework, which is going to make life difficult for anybody using a copycat suit to avoid that. They'd have to deal with it somehow.
Yeah, and we'd had extensive arguments on why the work was not obscene. I mean, you're dealing with, and part of our argument is with respect to the work not being obscene did make it into the ruling. And this is something I think we were all agreed upon, all the parties who were filing in this case. The petitioner tried to make the argument that a book could be found obscene just on the basis of select images or select passages. And one of the things we emphasized in our brief was, no, that's according to the standards that are set both in the Virginia statute and in the United States, the precedent set by the Supreme Court with respect to obscenity, is you have to look to the totality of the work. You have to look to the work as a whole. You can't just take out select images. And the petitioner was not having any of that. He was actually arguing at this local court that times had changed, that this local court should effectively overrule the Supreme Court and say that because we now have graphic novels as bad as genderqueer. I mean, this is part of what he was saying, that he was saying never before in the history of literature do we have a book that has images like we see in genderqueer, which if you know the history of comics, you know, is just complete nonsense. And the fact that we now have these books means we should be able to just look at select images and find the work obscene. And that factors into this decision that the judge makes in sections 2 and 3 of the ruling, that the petitioner just simply did not set out evidence that showed the work was obscene, which is different from saying the work is not obscene because it's more failing on the filing. But it was a really interesting thing to see happen in the case.
Importantly for us, the petition didn't even allege that the book taken as a whole was obscene. Instead, the petition alleged that these 7 specific pages, picked out 7 pages out of a 240-page book. And one of the arguments that we made in response is that he's not complaining about 97.1% of the book. He's only complaining about 2.9%. But the law, both constitutional law and Virginia statute, require that you have to find that the book taken as a whole exhibits a dominant theme of a prurient interest in sex. Well, the dominant theme isn't going to be on 2.9% of the pages, at least not in any of the books that I've read recently. So that's my sense.
Mm-hmm. And so one of the things Jordan asked is, what about the future? And Steve, you had mentioned in your conversation about where this case might go. You said one thing that might be interesting as we go forward. Where might this case go?
Well, I do envision future challenges. The fact that this one judge, and I should mention, this was a judge designate, not a regular judge of the Virginia Beach Circuit Court. She was brought in from out of town because all of our local judges here in Virginia Beach recused themselves. That's because in the Virginia system, legislators, including the lawyer for the petitioner, elect judges. So they were all not going to touch something that was involved with the legislators. So they brought in a retired judge from elsewhere. She can't be elected anyway, so she was immune from that. And the question then becomes, what happens next? I can envision that the same petitioner, well, not the same petitioner, but the same lawyer represented petitioner, or somebody with a similar point of view, might very well pick out another jurisdiction, maybe one more rural than Virginia Beach, maybe one where they think they can get a favorable judge draw, a little judge shopping, and find somebody who's likely to be receptive to the kind of argument they're making, and file a petition there. It is possible we could see pop-up arguments elsewhere across Virginia. I don't know of other states. I don't practice anywhere other than Virginia, but other states may or may not have procedures like this. Well, we could see other lawyers trying to find a sympathetic judge to say, yeah, I do think this is obscene taken as a whole, and therefore I'm issuing this ruling. That point probably would have to be resolved by the appellate courts. When a state Supreme Court pronounces it, it's binding on all courts throughout Virginia. One question that Jeff and I have battered about, not completely sure about this, is what effect this ruling will have beyond Virginia Beach. At first, I thought that it probably wouldn't have any effect beyond Virginia Beach because it calls for a consideration of local community standards. That is this locally considered to be obscene within Virginia Beach? But I think that would only apply to a finding that a book is obscene. In this case, the judge has actually struck down the statute, which is a really strong thing to do. And so while that ruling isn't binding on a judge in, say, Arlington or Richmond or Roanoke or somewhere else in the state, the judges are going to hear about it and they have to deal with it. They'll have to analyze it, and it would be useful as persuasive authority. Now, I'm going to actually step aside from my camera for just a few seconds, let Jeff answer something, give his take on that, because I saw we have a question in the chat box. It'll require me to go right over there and get my copy of the code book off the wall if somebody really wants to see the wording of the statute. So I'll be back in 10 seconds.
Oh, that's fantastic. Thanks so much. Jordan, do you have a question, or shall I just
I have sort of a wild card question, which is there anything about this case that you think has been underreported that you think people should know about, or Is there a specific thing you mentioned that people are misquoting the case or misconstruing it a little bit? Is there any like singular thing that you really hope people take away from the case, or that you think people really need to know about this case that may not be front and center?
I think there are two things. One, and this is something I've been talking about in our social media, is that the petitioner in this case didn't just call attention to the problematic, from his perspective, the problematic nature of the content of this particular graphic novel, but he wrote about how he saw graphic novels themselves were particularly dangerous for kids. And it's part of a growing movement across the country to have graphic novels taken out of education. There are people who see them problematic in terms of reading level, with flat out mischaracterization of the reading level of material in graphic novels, and also missing the importance of visual literacy. There are people who were reviving arguments from the 1950s. I mean, he's literally quotes in his petition, or in his brief, a book that was used in the great comic book scare in the late 1940s and early 50s about the pernicious influence of comics in young minds. So that aspect of it, I think, was underreported, and we should definitely pay attention to this, because it's going to affect the adoption rates of graphic novels nationwide if this point of view carries. Which gets to the question of Tiffany in the chat, which was, do I think the recent announcement by Barnes & Noble that they carry a more limited amount of books in their stores will affect the way books have been mired in these legal issues and parental objections, the way that they're sold to the public? Yeah, I mean, one of the biggest things we're seeing is soft censorship. There is a tremendous pressure on publishers not to accept manuscripts of certain types of books. There's tremendous pressure on stores not to sell them, and on schools not to, and the school market is significant. I mean, there are people who've reported that the school market can be up to 30 to 40% of the sales of a particular graphic novel. So we're looking at something where if this pressure continues, major percentage there's going to be a major percentage of sales drop off for certain graphic novels, and a number of graphic novels aren't going to be picked up, particularly if fewer and fewer are going to be even displayed in stores. So there could be a number of cases out there that we'll never get because the books were simply never acquired or never sold or never purchased. So Steve, you were going to answer the other question.
Actually, I want to offer one bit of commentary on what you just said. I am happy to report that I'm not old enough to remember the comic book wars of the late 1940s and early 1950s, because I hadn't been born yet. But I do have still dozens and dozens of my old comic books from the early 1970s. So I'm part of this guild, I think. The second question we had was about the wording of the statute. And I'll read little snippets from two different sections. The first one is the one that defines obscene, and it says that it means that which considered as a whole, that's where they start with the thing that we insisted on, has as its dominant theme or purpose an appeal to the prurient interest in sex, that is, a shameful or morbid interest in nudity, sexual conduct, sexual excitement, et cetera, et cetera, et cetera. That's the first thing, that's the definition section. Next is the code section that this petitioner proceeded under in filing a request for specific relief. This is the one that authorizes the court to say, yeah, I think this is obscene. And it directs the court in a hearing of this to consider the artistic, literary, medical, scientific, cultural, and educational values, if any, of the book considered as a whole. This is something that Jeff and I plan to jump in with both feet on if we had to have a hearing on this case. Second, the degree of public acceptance of the book or books of similar character within the county or city. Third, the intent of the author and publisher. Fourth, the reputation of the author and publisher. We were only too happy to do that one if we had to. Five, the advertising, promotion, or other circumstances. And then six, the nature of classes of persons, including scholars, scientists, and physicians for whom the book may not have a prurient appeal. This is the scientific exception. For example, a book on anatomy, we can acknowledge, might have images that you wouldn't want your average 11-year-old to be looking at, and that's different. The petitioner in this case was trying to invert that and say that there's a class of people for whom it's not obscene, and that's called adults. And we thought that's turning the statute on its head. That's not a limited group. But those are the provisions in the statute the court had to deal with. But remember, the court basically took this and slammed the book on it and said it no longer applies. I'm striking down the statute. That was a dramatic thing to do.
So we have just several minutes left. So I thought, yeah, we could just fully enter the Q&A portion of the seminar. The first one, which Supreme Court case established the precedent for local authorities to legally argue that comics and graphic novels could be obscene for consumption by children? That is by Brian.
Mhm. There are two, and I don't have the exact, we address these in our briefs, and I don't have the exact site of the Ginsburg case at issue. When Steve is talking, I'll go and pull that. But there are a couple of cases that are key here, because I know a number of people in comics think that a drawing can't be found obscene. And that's a problem, whether obscene as to children or to adults, But the test is not whether the thing is fictional or not, but the test looks to literary, artistic, political, and scientific value. So you could have something that's fictional that could, even a drawing or text that could be found to be obscene, even if it isn't, quote, real. Obscenity law has roots that go long before the development of photographs, before the invention of photographs. And so that's just one of the things that's tough to overcome in comics. So you look at the quality of the work, sort of the nature of the work, not the fact that it's fiction or nonfiction. But the case in question is Ginsburg, and I'll get you the site.
The Ginsburg case is Ginsburg versus New York from 1968.
Thank you.
I took the liberty of looking up where you were talking. So if you're a law geek and you want to look it up, it's volume 390 of the United States Reports at page 629. So 390 US 629. I think the other one may very well, the seminal case that we were citing a lot was Miller versus California from 1973. So 5 years later, they issued another one that really, I think that shaped obscenity law in America. And it still continues to do so, in my opinion. Jeff, you agree?
Yep, 100%. That's the bedrock.
We have a question from Jay. For teachers, any advice on phrasing for a content warning for students, parents, concerned parties wanting to teach genderqueer? That
is an incredibly thoughtful question. And it's incredibly important because one of the things that the lawyer who brought the case in Virginia, the lawyer who argued the case in Virginia, said is that, as Steve mentioned, he's a member of the Virginia Assembly, so he gets to propose legislation. And he said one of the things he's going to do, whether he appeals or not, is introduce a bill in the next session to impose codes on books, so that books have to, much like there's a ratings code for voluntary ratings code for movies, voluntary codes for games and that sort of thing. He wants a mandatory state enforced code for graphic novels and other works. So I know that, and I think if that happens, I'm going to be right. We're going to be right there challenging it. But in terms of phrasing for a content warning, that is a question on which I'm going to have to think, and I might even have to think and get back to you on this one, Jay, after the session, because I want to be very, very careful about what I say. One of the things we emphasized in the briefs was that there's been a shift in American law as to, very recently, as to what we consider, say, protected class, protected in American civil rights law, rights in the workplace, rights, and I think it's also happening in schools. The Supreme Court just very recently ruled that diverse gender expression was protected under Title VII. I think that this is widely seen as discrimination on the basis of sex includes discrimination on the basis of gender expression across all forms, whether or not it's something that deals with employees in the workplace. And I also know that there's a movement of on that tip in laws, state and local laws, like state and local jurisdictions nationwide. So one thing I think that we're going to have to start talking about in schools when we discuss these issues is that since the Supreme Court is recognizing sexual expression, same-sex relationships, as something that is protected in civil rights law, it's something we have to be able to discuss. And I think in terms of any disclaimer, in terms of material, and whether people may think that this is appropriate or not appropriate, I think we also have to have a new bedrock of acceptance for the discussion of these issues. And I think a disclaimer shouldn't just say, "Hey, this is something that people might find problematic," but the disclaimer should also say, "Hey, this is something that we should be talking about." But in terms of precise wording, excellent question. I want to think about that further. Steve, do you have any thoughts on that?
I can't add anything to what you just said there.
I have sort of a side comment to that, which is it may be helpful to look at like teaching guides that have already been written about that. We have a section on our website called Adding Graphic Novels to Your Library Collection. And in the case of genderqueer, at least, we've looked at and linked to some of the reports from schools that have had genderqueer challenged, and they've decided to retain it. And there's the sort of readers' reports of why they decided to retain the graphic novel. So looking at things like that might be, it's not, you know, a content warning per se, but it might help, you know, just looking at it from a slightly side angle, sort of help boost why it will be included with your teaching for that year, or why it will be available for students in the library.
Yeah, I think it's incredibly important, and it's one of the themes that runs through the material on our website, that people understand that it's not simply that there are problematic images, but it's, which is what a lot of these ratings do. It's like the famous one that Neil Gaiman makes fun of, you know, warning contains language in the rated R in movie context. But we got to get people educated through these disclaimers and these discussions that this is material with meaning. This is material that matters. That these are discussions that, particularly when you're dealing with adolescents and, you know, kids in high school, these are things that it is healthy to discuss. They're part of the national conversation now. The Supreme Court says that this is protected, that these people are part of our community. You can't say that to kids. I mean, it is fundamentally unjust and inappropriate to say to kids, well, yeah, they're part of our community and we tolerate them, and they have legal rights, but you just can't talk about them or see them. And it reminded me a lot, and we actually put this in the brief, of times when, you know, Steve and I grew up in a different era from now, where in certain things we were still, you know, when I was a kid, the whole notion of interracial marriage had just been allowed as protected by the Supreme Court. When I was in law school, same-sex relationships, the Supreme Court said, you could go to jail for having a same-sex relationship. There was a Supreme Court case that said that. It was overturned years later, but when I was in law school, it was illegal. It could be illegal in several states for you to be gay. I mean, that was the law. And when the interracial marriage and civil rights were new, I remember people said, well, these things are important, they're rights, but kids can't see them. When the precedent with respect to the illegality of homosexuality was overturned and gay marriage was allowed and same-sex relationships were no longer criminal, there were people saying, well, you know, that's great, they have rights, but kids shouldn't see that. And that's what's being done now with gender expression and other things, and that has to stop. And I think we need to be able to explain in our schools why that has to stop. Steve, I'm sorry, I went on a little rant there.
No, you're allowed to rant all you want. But the one thing I wanted to mention is I know we're getting close to 1 o'clock, but because I came on late, I'm willing to stay later if anybody wants to ask further questions. I normally don't want to go past the hard stop time, but this is not the usual circumstance. Getting kicked off Zoom takes real work.
Do we have any additional questions? Because we've had amazing questions so far, which I really appreciate. And I'm glad that Steve answered Lisa's question with respect to the statutes 372 and 384 in Virginia. I got to say, Steve, I have read more in Virginia law in the past 3 months than I ever thought I would read in my life. And it's been quite an education.
I never thought I'd read genderqueer either.
So there we go. It's been quite a session. And I have to say, Maia is another one of the great things about positive things to come out of this case. Was getting to meet Maia and having discussions with people about the case in the comics community, in the free speech community. The response that we have seen to this case is, to me, tremendously encouraging because there are people who, you know, I went on my little discussion a few minutes ago about why these bans matter and why this case matters. There are a number of people across the country who see that and are fighting for genderqueer to be part of their schools. that are fighting for, Flavor and New Kid and Class Act and so many Fun Home, drama, so many books that have been challenged that they want to see kept in their schools. And that's tremendously encouraging to me for the future.
All right, the only thing I'll add other than that, again, unless we have any questions, is the litigation isn't formally over. The judge has issued a ruling and the clock is ticking for the petitioner if he wishes to do an appeal. He has another 10 days to file a notice of appeal. If he doesn't file that, then this lawsuit is over. If he does, then it'll go to our state court of appeals. I think I know what I'm doing up there, so we'll have. But we'll argue the case at a different level. But we don't know yet whether it'll be finally over now. That's up to them.
And does it, the state court of appeals, and just so everybody here knows, is that the Virginia Supreme Court? Is it a level below the Supreme Court? How does that work?
We have the Court of Appeals of Virginia is the interim court, and that's where it'll go first. They would have an appeal of right, so they don't have to ask for permission. They can simply take it there. If this Court of Appeals issues a ruling and either side is dissatisfied, then that party can appeal on to the Supreme Court, but you have to convince them to take the case.
Is that the
Virginia Supreme Court? Yes.
Okay, good.
Yes. And since there are constitutional issues in here, assuming that's part of the basis of the ruling, it would be possible to appeal it on to Washington, to the Supreme Court of the United States, but that's a ways down the road. If there is an appeal, it probably wouldn't be resolved for another year.
Got it. Okay, that's incredibly helpful. And I have to say, another good thing that's come out of this case for me personally is the opportunity to meet and to work with Steve Emmert, who is an absolute gem. And everybody who gets to work on a case would be lucky, incredibly fortunate to work with Steve. I got to thank you because you've been tremendous from day one.
You're very generous, and I appreciate that. Thanks very much.
Thank you so much. For me personally, thank you so much for helping to defend comics. That really means a lot. Did you shared the Virginia policy? Do you want me to share that with everyone in the chat?
I wanted to give you an opportunity to do so because I mentioned it earlier on. This is a policy handed down 3 days ago by the governor, who has rescinded the one that his Democratic predecessor announced in March of last year. So this is now the policy in Virginia, and I've given you just a couple of the highlights. There's a New York Times story about it, I think, right today. So if you want to check that out, you can get a summary of it. But this is the link to the actual policy now. That's from the Department of Education.
Excellent.
Right.
So if we have no more questions, I just want to thank Jeff Trexler and Steven Emmert again. Thank you so much for your work. Thank you for taking the time out of your days today to come be here and speak to us. Steven, thank you for sticking with it and not giving up with the Zoom webinar. Really appreciate that.
I'll have a few four-letter Anglo-Saxon words to tell to the folks.
And everyone else, please check out CBLDF.org for news updates. We have plenty of resources for defending books. You can always go to our site to also report censorship, which is really huge, to ask for assistance, and also to become a member or donate to help us fund cases like this one. So please visit our site, CBLDF.org. And thank you everyone for coming to this event today as Comic Book Legal Defense Fund kicks off our celebration of Banned Books Week.